Connecticut follows the Federal Consumer Credit Protection Act formula as its baseline, but applies Connecticut's minimum wage, which significantly exceeds the federal rate, in the calculation, increasing the protected earnings floor for Connecticut workers. The Connecticut garnishment limit, the lesser of 25% of disposable earnings per week, or the amount by which disposable earnings exceed 40 times the Connecticut minimum wage. Connecticut uses the 40 times state minimum wage formula, which at Connecticut's elevated minimum wage produces a substantial protected weekly earnings floor. For lower-wage Connecticut workers, this formula may effectively prevent any garnishment. If disposable earnings are below 40 times the Connecticut minimum wage, no amount is subject to withholding. Disposable earnings in Connecticut, gross wages minus legally required deductions, federal and state income taxes, Social Security, Medicare, and Connecticut income tax. Voluntary deductions are excluded. Connecticut garnishment procedure. Connecticut requires that a prejudgment remedy, attachment, or similar relief be obtained before a garnishment can proceed in many cases. Post-judgment, the creditor obtains an execution from the court and serves it on the employer through the proper officer. The employer must respond and begin withholding within the required time frame. Connecticut mandatory payment notice. Connecticut has specific requirements for notifying debtors of their rights in connection with wage execution, including information about available exemptions and the right to claim exemption from garnishment. Exempt income, Social Security, unemployment, workers' compensation, disability benefits, and retirement income from qualified plans are generally exempt from garnishment in Connecticut. People Locator Skip Tracing identifies current Connecticut employers for wage execution proceedings, results within 24 hours or less. Visit peoplelocatorsskiptracing.com to place your order.